up in any family law proceeding, and it happens quite often, is to bring a motion for temporary relief.
Yeah.
Okay, now this is you and I had these discussions before. So now what we're talking about is to get through that whole process, to have your MIPS completed,
Right.
to go through your first appearance, then maybe a DRO conference, and then you have a case conference, and then you have a settlement conference, and then you have a trial management conference, and you
Okay,
could
yes.
have multiple of each of those. It can be anywhere from, if it's really speedy, 6 months to years before your matter actually gets scheduled for trial.
Yeah.
But in the meantime, you've got a family that is broken down.
Right.
If there are kids and the parents can't agree on where the kids are going to live, where they're going to go to school, how much support is to be paid to the one that has the kids living with them, are the kids to be split 50-50? Are they going to be sharing decision making?
Yeah.
You need to quite often ask for an order or agree to an order, because you're going to have something in place to stabilize the situation until you get to trial.
Right.
So for that reason, people can bring motions, which is saying in the middle of the court process, saying, until we get to trial or we manage to get everything resolved on consent, we need an order in place now dealing with these issues. And you do that by way of a motion.
Yeah.
Now, and what the motion will do, once a motion is an order, a temporary order is made on a motion in the proceedings, that temporary order will stay in place until the trial actually occurs. So it can be in place for a long, long time.
Right.
Now, the rule about bringing motion, though, is you can't just start an application and with your application serve the other party with a motion for a temporary order. The family law rules are very clear and very, very specific. Except in exceptional circumstances, and we'll talk about that a little bit more, you cannot bring a motion for a temporary order dealing with custody, access, support, property, exclusive possession of a home. You can't do any of that by way of motion until you've had your first case conference with a judge.
Okay.
So nobody's allowed to bring a motion for a temporary order until you've had that first case conference, because at the case conference, both parties will have the benefit of listening to a judge who hopefully is trying to talk sense into two people, one or both of whom might be being completely unreasonable, to see if you can get things settled down and get an order that actually makes sense and that will calm the situation down. If that can't be done, then once you've had that first case conference before a judge, either party is free to bring a motion to go to court to ask for a temporary order. Now, the only exception to that rule about you can't do a motion for a temporary order until after your first case conference is if you're dealing with an emergency or an urgent situation. But like, let's say, for example, you've got a couple that is separated and the parties are originally from another country, and the kids are with mom, and mom has already told dad that she is taking the kids to their home country and leaving the province, leaving the city, leaving Ontario. In that kind of situation, then either party can bring an urgent motion, which means that you are going to court to request the judge make an order before your case conference. Sometimes there are people that even bring an urgent motion because of the time limits that are coming in, that they need their order even before they've served the application. So it's just saying, whoa, we really have an emergency situation here. This has to go before a judge. We need an order right now to stabilize the situation or to prevent something from happening. Usually it's if there's a threat of physical harm or danger, or if somebody is threatening to remove a child from their jurisdiction. Those are generally the kind of things that they have to do. And there are very strict legal tests that the court will look at before allowing you to bring an urgent motion, i.e. to have a judge hear your motion before you've actually gone through a case conference. You have to establish the urgency. I have quite often seen situations where the people that are separated, they kind of worked out between themselves on an informal basis what they're doing and who gets the kid when. And then all of a sudden you got one parent who had taken the kid on a Friday and the kid is supposed to go to the other parent on Monday. And the parent that took the kid said, well, I'm not giving you the kid back. We're moving to Nova Scotia tomorrow.
Right.
And there's not been a court proceeding started yet or anything else, then the person who's not agreeing to that happening can bring an urgent motion to stop the child from being removed from the jurisdiction. So You're talking about pretty extreme
Right,
situations
right.
for an urgent motion to actually occur.
So I think
Okay?
that the courts usually generally try to, I guess, triage, I don't know if it's the right word, to try to have
Yes.
these heard as soon as possible, won't they? Like,
Okay, when somebody brings an urgent motion, it's done
yeah,
by it's a Form 14A notice of motion, and
yeah,
then it's accompanied by a Form 14B affidavit.
yeah,
And when the notice of motion and affidavit are prepared,
yeah.
court staff take a first run at it to
Okay.
say whether just on the at the very basic level, does it seem to meet the requirements to even
Okay.
bother putting the draft material in front of a judge? They
Mhm.
will not issue the notice of motion. They will not give the person a date for the motion to be heard, but they will triage it at the courthouse level, and they will tell the person, if no, we can't put this before a judge, you're going to have to get legal advice and figure out what you need to do, or no, this isn't going to fly as it stands.
I see.
Court staff will not give legal advice. They will not
Mhm.
say this is what's wrong with your motion. What they will do is say we can't issue your motion, get some legal advice
Oh,
to figure out what your options are and what you can do, or go back and try figuring it out on your own. But even then, again, in most jurisdictions, then what happens is if it passes the triage by the counter staff,
yeah.
then draft urgent motions will go before a judge.
Oh,
And the judge will
wow.
review the documentation. And I've seen, again, I practice in Hamilton
Right.
and in the Niagara region. I have seen cases where somebody has brought an urgent motion, the materials have gone before a judge.
Mhm.
The judge has reviewed the materials, never seeing the person, never speaking to them, never doing a hearing in court, just on the basis of reviewing the materials.
Yeah.
The judge will make an endorsement and make an order saying, I've
Oh,
read the materials. If this person wants a motion to proceed, I want to see the following or whatever. So they'll say, okay, yep, we'll let you do it, but there's things you need to do first.
I see.
Again, one of the things that happens on an urgent motion is one of the first decisions that have to be made if you really think you have to bring an urgent motion. Do you have time, or is it an appropriate situation where you serve the other party with the motion first?
Oh, yeah.
Or do you just go ahead and do it on a without notice basis?
Right.
And I've seen a lot of motions started either by lawyers too, to be totally fair. We don't always get it right the first time around either.
Right.
But an urgent motion that is brought on a without notice basis,
Yeah.
and the judge will review the documentation and will say,
Mhm.
I will hear this motion,
Yeah.
but you have to serve the document, the notice of the motion, the affidavit on the other party. And this is when I'm going to be hearing the motion, and the other party has the opportunity to either
Oh,
append or file
interesting.
responding material.
Mm.
Even though the person has said, I'm asking for next party order, i.e., I'm asking you to make an order without the other side even knowing about it until after the order is made. Now,
Mm.
and there are circumstances where that is necessary and the appropriate thing to do,
Mhm.
but judges do really, really hate being put in the position of being asked to make an order without hearing from
Yeah.
both sides whenever
Yeah.
possible.
Of
So
course.
again, that's why they will quite often make that saying, okay, you brought this as a without notice motion. No,
Mm.
give a copy to the other side. This is when I'm going to hear this motion. The other side is going to have the right to attend.
Mhm.
So